早上好，香港法律周2023第3天的活动调解仲裁新领域即将开始，请各位可以就坐，并且把你的手机和电制设备调到静音的模式。我们同时欢迎线上观众同步参与活动。我们今天的活动设有即时传译服务，并设有粤语及英语频道。在场人士可以在会场的门口处领取耳机。如果你现在需要耳机的话，请举手，我们的工作人员会向您提供。线上同步的人士，你可以透过直接点击屏幕上显示的频道去选择相关的语言。Good morning, ladies and gentlemen. A very warm welcome to Day 3 of the Hong Kong Legal Week, New Domains in Mediation and Arbitration. The morning session is about to begin, so please take a seat. Do remember to switch off your mobile phone or turn it to vibration mode. The 6th Shanghai-Hong Kong Commercial Mediation Forum will be conducted in Mandarin with Cantonese and English channel. Today, we have simultaneous interpretation service in English and Cantonese. You can take the SI headset at our entrance. If you need a headset, please raise your hand and our staff will provide you one. For our online participants, you can choose the preferred channel on your screen. And we would also like to welcome our online participants. Thank you.
This is mute.
Distinguished guests, today's forum will begin soon. Please be seated.
About to begin. Please be seated. 各位嘉宾。
Distinguished guests, ladies and gentlemen, good morning. A big round of applause to everyone. And for all the friends here, please be seated and welcome to the 6th Shanghai-Hong Kong Commercial Mediation Forum, jointly organized by the Department of Justice of the Hong Kong Special Administration Region and the Shanghai Economic and Trade Commercial Mediation Center. Today, our forum, the theme is Building the Asia-Pacific Dispute Resolution Hub to Enhance Shanghai-Hong Kong Commercial Mediation Cooperation. We warmly welcome all the guests attending. I'm your MC today, Yuki. And now, let's welcome the Honorary Chen Kwa-kun, SBS JP, Deputy Secretary for Justice, Hong Kong Special Administrative Region of the People's Republic of China, to the stage. And let's welcome Judge Hu Fang, Vice Chief Judge of the 4th Civil Division of the Supreme People's Court. A big round of applause to her. And let's welcome Mr. Wu Jianyong, Director General of Shanghai Municipal Bureau of Justice. And big round of applause to him as well. Thank you for coming all the way. Let's take a look at the cameraman just in front of you. Let's try. And the mobile phones back. Smile. And look at the official cameraman. Another one. Please stay on the stage. And let's welcome the first session speaker, Dr. Christopher, to come to the stage for the photo. And Mr. Huang, please. And our moderator, Mr. Stanley Low. Big round of applause to him. And Shanghai's Party General, Mr. Shun here. Thank you so much. And we welcome your remarks and insights later on. Look at the phone in the back. Thank you so much. Please be seated. And Mr. Zhang, please stay on the stage. Thank you. And now let's welcome DSJ, Mr. Chang, to give us an opening remark. Welcome. Distinguished Miss Hu, dear guests, friends, good morning. On behalf of DOJ, I welcome all of you to attend Legal Week. In the morning, we have Shanghai Mediation Center, Shanghai Law Society, Hong Kong Mediation, and DOJ Hong Kong. This is the 6th time we hold such an event. Our theme today is to form new domains in mediation and arbitration to enhance the cooperation between Shanghai and Hong Kong. This year is the 10th year for this Belt and Road Initiative. This initiative promotes the connectivity of infrastructure and mutual cooperation. And now it has become a very important platform to build human connectivity. And we have connectivity to face the whole world and connect with mainland China. And we play a very important role in Belt and Road Initiative, and we are committed to become a platform to solve international arbitration. And Hong Kong is the only common law practice place that is in line with other major economies. We also have multilingual experts in law area here in Hong Kong. We need to leverage on our unique advantage to cooperate with Belt and Road Initiative. Hong Kong SAR government on October 25th, we delivered the speech and we mentioned that we would like to forge Hong Kong as an international law center in Asia Pacific. And thus, DOJ in next year will establish a special office and experts panel to promote Hong Kong as a training center for legal experts to facilitate cooperation and communication along Belt and Road region. And we hope we could foster more talents in terms of mediation and law area. And next year, we will review our mediation mechanisms to make Hong Kong's mediation more professional. For mediation in recent years, it is more and more popular. It's time-saving, cost-effective, flexible, confidential, and also it's conducive to maintaining the relationship between two parties to cater the needs, and also with the help from central government. Our coordination office was established in February this year to complement our 14th fifth-year plan for Hong Kong to become an international legal arbitration and mediation center. If you are interested to know more about how to solve the international arbitration, you're more than welcome to attend tonight's event, which will be facilitated by Mr. Sun Jing. That is also the 5th Hong Kong mediation workshop. Other than infrastructure disputes, regarding cross-border disputes, we also play a very important role. We have very soft and full-scale mechanism to ensure the effectiveness of enactment, and we also ensure we would like to solve the cross-border dispute. We are actively promoting Greater Bay Area's arbitration integration. GBA guidelines, as well as GBA, Hong Kong, Macau, and Guangdong, 3 areas justice departments. We 3 parties talked and then released a rule last year, and it will play a leading role to facilitate the GBA area to become a region to adopt this mechanism. We are also actively researching and making the policy alignment in GBA. We are leveraging on UN Compact as a reference to promote GBA's mechanism integration. Later on in the first panel, we will talk about the cross-border and also international listings real practice to further enhance Shanghai and Hong Kong's listing mediation service. I look forward to each speaker's sharing later on. In capability establishment and training, DOJ is committed to forging Hong Kong as an international investment and arbitration center skills fostering center to build a leading role in Asia Pacific region, to provide training, a professional team to this region. Since 2018, we have been holding investment law and international dispute resolution courses and training lessons. It is actually complement with the international mechanism to encourage mainland China investors to tap into Hong Kong's mediation services to solve cross-border disputes. We'll continue to hold the fourth training session. For more details, please check out DOJ's website. At that time, we also hope you could actively participate. And in recent years, Hong Kong and mainland China have been actively working on listing mechanism to provide a professional foundation for listing. And in Hong Kong, we notice to provide training for listing entities and agent is very important. So the second session will discuss how to, through systematic training, to provide training for listing entities and then to find their best solutions to resolve dispute. I also look forward to each speaker's sharing and discussion then. We hope the public could enhance their awareness on mediation and dispute resolution. That's a very critical part. Hong Kong Star government issued a speech, and then it mentioned the region will deepen our culture and strengthen local mediation mechanism, including in the government agreement. We will revise certain clauses and encourage organizations to join our training to empower the experts in terms of mediation skills. In terms of promotion and publication, DOJ have been actively through different methods to promote mediation in China. For example, we have Mediation First movement, and we encourage society to mediate first to resolve disputes. Since 2019, we have the Mediation First agreement. We bring it to Shanghai and Shenzhen Qianhai. And in Bangkok, Thailand, in an event, it was our first time we promoted our agreement there. We are planning next year to promote the Mediation First agreement in Greater Bay Area. We hope in Asia we could promote this idea and let people know the advantage of mediation here in Hong Kong. In May next year, we will have another meeting. We hope that through different seminars and activities, we could further deepen citizens' understanding on mediation. At last, I hope through today's event, we could gather our thinkings and have deep understanding and mutual communication. And we hope in Hong Kong and Shanghai, these two regions could supplement with each other in terms of advantage to help with Belt and Road Initiative of China. And once again, thank you again for all the organizers and participants. And thank you for all the speakers to take out some time from their busy schedule for the sharing here. And here, I'd like to wish the whole event a whole success. Thank you so much. Thank you, Thank you. Please be seated, Mr. Jim. And now let's welcome Ms. Hu to give her speech. She is a Vice Chief Judge of the 4th Civil Division of Supreme People's Court. Welcome. Distinguished Mr. Zhen, Mr. Huang, good morning. I'm happy to be here to attend the 6th Hong Kong and Shanghai Listing Arbitration Mediation Forum. On behalf of Supreme Court, I'd like to congratulate on the opening of today's event. This year is the 20th year of establishing this mechanism. In the past 20 years, Hong Kong and Shanghai's commercial cooperation has become more and more intense in terms of shipping and other areas. We achieved a lot of fruits, and I think all of these cannot be achieved without a sound law system. And to have the international listing mechanism, I think Shanghai and Hong Kong are important window to outside world. For this forum, it is actually a more normal platform for our two regions, and we can all see the achievements we have arrived. With the further opening up and reform, I think we have more and more international disputes, and apart from arbitration and mediation, other new forms of dispute resolution have been coming up. And I think there are several characteristics in terms of listing. First is we are moving faster. In 2021, after the civil law revision, we applied more to our other areas. And in terms of different entities, we have clearer cases jurisdiction management. And we hope listing, mediation, and dispute resolution can be applied to a broader cases to promote law application, to have more China characteristics shaping pattern and landscape. And then Supreme Court also issued a lot of papers for listing. We are more tailored to the revision. Second is in terms of diverse and rapid development in terms of listing. Nowadays, we have more and more listing and registration organizations. We have International Promotion Commission and other different organizations. And we also have civil nonprofit organization, third-party listing mediation center to prevent disputes, and it played a very important role. And third, listing and other dispute resolutions integration, we are seeing its initial effect. And we launched a listing dispute resolution agreement and other documents. There we mentioned we need to actively use and also integrate our dispute resolution mechanism. In 2018, the Supreme Court established a one-stop diverse dispute solving, and we attracted 10 listing arbitration organizations and 2 mediation centers. Hong Kong Dispute Center and also Shanghai's Mediation Center are part of them. We made a lot of effort, and also we are having more and more impact in terms of international dispute resolution. It has become the latest trend to cater to international listing entities' needs to foster a more legalized business environment and operation environment. In Hong Kong, we have a long-time development. We are seeing much more well-fledged mechanism, especially in GBA regions. We are seeing Hong Kong's listing mechanism have been including into the mainland China, and we're seeing more opportunities. We've become the hub of the legal dispute resolution center, and we have cloud services as well to establish the first mediation-first platform that is government to government. And we also have coordination offices here in Hong Kong. It signals that Hong Kong, as a law center and dispute center, we are strengthening our role here. And for this forum, we are trying to foster our position as a center and to cater to the two place's needs. And we would like to add more training courses to facilitate cross-border mediation cases. We will discuss in these two panels, and these two panels have constructive role. I would like to mention 3 advices. First, to further strengthen the top management and design of the structure. Second is to faster the progress. We need to revive the top structure instruction, and from legislation, jurisdiction, and mechanisms, promotion, etc. We hope we can make more integrated arrangements to promote specific and also more holistic integration. We also would like to train more professional arbitrator and mediators. We have a lot of work which needs to be promoted in parallel with each other to have a more healthy development. We encourage more Chamber of Commerce and companies to choose mediation first, to choose mediation as the first way to resolve disputes. We hope we could actually execute what our president said to foster society governance and management, to prevent and also reduce disputes from happening. Second is to further strengthen the listing professional and more tailored way. Professionalism is actually a basis to win people's trust. And also we need to make a more professional organization and to have more standards and to have more numerous processes. We hope we could have confidential, low-cost rules to build business relationships. We hope that in financing, securities, and international law, intellectual properties, and other areas, we could tap into mediation. And we hope we could have more mediators who can deliver or provide professional services to public to build a more trustworthy platform and more impactful. We could actively explore the market opportunities and have more transparent charge and fee system to have a more healthy mechanism. Third is to strengthen or facilitate the internationalization of mediation. With the SMC, it symbolizes a very important step. And the World Bank also listed dispute resolution as an important indicator for international operation, and it further promotes the internationalization of mediation. In April, Supreme Court of China had signed with Singapore Supreme Court signed a framework under Belt and Road Initiative, our cooperation MOU. We hope that a more flexible, cost-effective mediation system could help dispute resolution, and it also shows the very important role that it plays. We hope we could have more international horizon and to accelerate the enactment of mediation. And we hope we could have more integrated mechanism between China and international, attracting more international mediators to join us, and we could have more innovative mediation ways to have more effective ways as well. We hope the whole systematic China characteristics mechanism that is in par with international standards and rules to improve our country's international impact in terms of mediation. Supreme Court will continuously support listing mediation's healthy development and to support China and Hong Kong's cooperation to solve dispute resolution. And we hope all parties, professionals, could promote and join us to together promote the listing to take it to the next level to achieve better results. And lastly, I'd like to wish this forum a whole success. Thank you. Thank you, Ms. Hu. Please be seated. Thank you. We're honored to have Director General of Shanghai Municipal Bureau of Justice to deliver the opening remarks. Mr. Wu Jianyong is unable to be here with us today. He has shown his support for the forum by delivering a recorded video speech. Let's take a look. Distinguished Mr. Chen, Ms. Hu, and each colleagues, good morning. At this time, the 6th Shanghai and Hong Kong Mediation Forum is open. And on behalf of Shanghai DOJ, I'd like to wish the forum a whole success. Also, I'd like to take this opportunity to show all the colleagues, thank you so much for coming here, and thank you so much for your support along the way. This forum, since 2012's first inception, it has attracted United Nations, EU's Intellectual Property Bureau, US, UK, Singapore, and other mediation organizations' attention and active participation. We covered a lot of topics and achieved a lot of achievements. And under this environment, and in other areas in terms of mediation arbitration, we achieved a lot. It has become a very important theory, research, and innovation cooperation platform. At the moment,
we will try to provide very professional services and use our special advantages in order to provide resolutions for international disputes, to also to better our mechanism and systems, so that we can play an irreplaceable role in this area. We have already, under the guidance of our President, Mr. Xi's idea, in order to guide our daily work, especially to lead the whole plan for the legal services in order to provide very full services in the legal area and to make it a better along the daily professional work, and to set up in Shanghai to to make it become a highland in this area, to play an important role and actively to promote a mechanism, and at the same time to train experts in this area to make it more marketed and international, further to make it research in different special areas, and to use this new mechanism in order to make sure that the fully development in Hong Kong and Shanghai. Shanghai and Hong Kong are the windows for mainland China to the international platform, and we have the coincidence in providing further promote the regulations in this area, train the experts in this area, and use multiple methods to promote, make sure these two goals can be achieved. We would like to set up or build our highland for Shanghai and Hong Kong to become the international dispute center in globally, in order to hope, and we hope we can cooperate further to promote the development and make it more vibrant, vivid. And going forward, we'd like to further enhance the cooperation between the two cities in the trainings and promotions and knowledge researches in this area, all cooperating corporately together to promote the forum, and especially the events and activities like this one, to further promote the cooperation and to promote our legal services, especially mediation services, especially to contribute for the Silk and Belt and Silk Road. At last, I would like to wish the whole success for this forum. Thank you. Let's give a warm welcome, Mr. Sun, Shanghai's dear Mr. Zhang, and also Mrs. Hu, Mr. Huang, and dear guests, friends, good morning. On behalf of Shanghai's current enforcement mediated settlement agreements, on behalf of our organization and other relevant organizations, to thank all the efforts this forum provided. In June 5th, Mr. Li Qiang, our Prime Minister, has mentioned that China has further promoted the further open up in Shanghai in order to cooperate with international organizations and professional experts to further promote further opening up. So this forum today, in order to provide a highland for the cooperation between Shanghai and Hong Kong to become a service center for international mediation services on international disputes. We have provided Asia Pacific area to provide such service centers in order to make sure that we protect the Belt and Road, the leading role over there, making sure that we can provide professional services and to play an important role in this specific area. The government would like to make sure that we have very professional services, consider the international professional services in this specific area, making sure China could become a critical part in it too. In 2022, the trade between Shanghai and Hong Kong is 160 billion Chinese yuan. That makes sure, and the daily trade has tripled. With the development in cooperation between Shanghai and Hong Kong, the government would like to make sure that Hong Kong and Shanghai would like to play a center role, and as well as Shanghai, to cooperate further. And we have the 8 disciplines for Shanghai and Hong Kong's cooperation. And in order to achieve this goal, we have set up different methods and protecting mechanism to make sure this goal can be achieved. We have covered 13 areas in cooperation between the two cities, among which this forum has listed one of these events in the list to further cooperate, deepen cooperate, and more efficient cooperation between the two cities. The 6th forum today is under the big background of the government supporting the two cities to cooperate further in this particular area, making sure that it's more competitive in this specific area. We would like to make it more professional, more international, and making sure we have relevant seminars and activities in order to achieve such cooperation. And this has played a critical role between the two cities. In most recent years, we have done multiple methods and work in order to achieve the goal. And especially with the background that the Singapore Supreme Court's further regulations and the China and U.S. cooperation mediation mechanism, we have set up different mechanism. We have set up different seminars and activities, including professional mediators, including 6 Hong Kong mediators, to enhance and leverage their professional services in mediation, providing mediation services. And to promote, in Shanghai, actually, we set up several documents and legal mechanism to further promote its more professional in building up mechanism in Shanghai. We hope that we can share the resources between the two cities and further collaborate with different organizations to further promote the international cooperation and also cross-border cooperation between Shanghai and Hong Kong, and to collect different insights and ideas to promote further for this initial goal. Lastly, I just wish whole success for this forum. Thank you. Let's give another round of warm applause, Mr. Hu, Mr. Sun, Mrs. Hu, Mr. Sun, and Mr. John's wonderful opening speeches. Thank you. We have two discussion sessions for today's forum. The first one is that several issues of several cross-border enforcement settlement agreements reached through international commercial mediation. The second is to build up the mechanism in this particular area. If the guests have any relevant questions, please scan the QR code on the screen, and you can upload your questions there. In the following sessions, our guests will answer your questions. Without further ado, let's start the first session. Several issues of cross-border enforcement of settlement agreements reached through international commercial mediation. We have welcomed Mr. Huang, Mr. Chen, Ms. Tao, Dr. Tao, and Dr. Marcelo for their speeches. Mr. Hu, me as Dr. Marcelo cannot participate in person in today's program, so he will join through the video later. Let's welcome Mr. Hu Xie first. Let's invite to share guests, including Mr. Huang, Mr. Chen Nanwei, Mr. Tao Rong, Dr. Tao. Let's invite the three guests. Dear Mr. Zhang, Mrs. Hu, Mr. Sun, ladies and gentlemen, friends and guests, good morning. Welcome to our today's Legal Week, Hong Kong. This new domain, our forum. Welcome. Our event is co-organized in today's This forum will discuss development of Shanghai and Hong Kong's commercial mediation services through constructing regional regional services, constructing regional commercial mediation relevant training mechanisms. This is my first time ever to speak Mandarin in public events. This is very challenging for me. Hong Kong is the special region between mainland China to the international world. We have learned two languages, English and Chinese, in Hong Kong. Being able to speak both languages, Cantonese, English, as well as Mandarin, Cantonese Mandarin. We have this privilege to learn these three languages, even though I lack of the opportunities to speak in Mandarin in public. We're very honored to invite the three guests and experts and very experienced mediators. They will share with us how to enforce the international mediation settlement agreements, especially Professor Huang. Mr. Huang is the chairman of the China's legal services and platforms of multiple organizations in this area. Mr. Huang, Professor Huang, he was used to be the vice president of Universities Wuhan and China's legal and legal universities in mainland China of 2 universities. Mr. Chen is also an experienced mediator in this area, and he is the Mr. James mediator, worked for this professional organization, and he's also the chairman of the Intellectual Property Association of China. The department that I represented, which is the Hong Kong Mediation Council Limited, we have played actually multiple important and critical roles in this particular area. The previous chairman of this
爭議解決嘅樞紐地位咧，發揮咗好重要嘅作用。此外，佢都有做調解員啦、仲裁員啦，同埋法律教授。佢亦都擔當過好多行業機構嘅主席同埋董事會嘅成員。目前咧，阿陶博士咧係香港。
Right now, then he is the chairman of the Mediation Council. And actually, my son is learning from him.
马杰洛博士是原欧盟知识产权局上诉委员会的主席，他是一位经验丰富的国际调解员。我之所以说他是国际调解员，是因为他懂5种语言，希腊语这是他的母语，他也会说西班牙语、法语、德语和英语。不幸的是，马杰洛博士今天早上没有机会亲自参加我们的研讨会，不过他为我们预备了一个简短关于执行
But he prepared a video for us this morning. I'd like to invite Mr. Huang's. We will discuss first the several issues in enforcement of international mediated settlement agreements in Hong Kong. Let's welcome him. Thank you, guest. Thank you, mediator. Your Mandarin sounds good. Thank you. Thank you, dear Mrs. Hu, Mr. Zhang, Mr. Shen, dear guests, colleagues, ladies and gentlemen, good morning. I'm very delighted to be invited to participate in the 6th forum of the International Mediation Services. It's my 6th time to participate in this. Thank you very much for your invitation. I hope today's topic, where we discuss the agreements, the settlement agreements, and also the cross-border enforcement, several issues about this. We now know that this is the method and the mechanism and the center in this particular area through the international settlement agreements. In this particular area, whether we can enforce such agreements. This issue has involved the protection of the relevant parties, the international listed security and safety and stableness. And we have to make sure that we study this and enforce it, making sure that it has very smooth process. The first issue, we will discuss the legal nature of the settlement agreements. In real cases, different parties would have multiple different disputes. But we all know that the methods that we solve such issues are several. We have mediation, we have lawsuit, we have settlement agreements, but all the methods have its own shortcomings and advantages. Which methods to be adopted would depend on the parties' independent choices. And the third party involvement should be regulated. So mediation actually is the legal mechanism in this area. And the settlement agreement is a legal document. We have, between the different parties, they have reached the new contract or new agreement in disputes. It has the nature of legal documents. Under the Singapore SAC, we have the Singapore Convention on Mediation, SCM. It has focused on the international cross-border enforcement. In this particular area, it provides several methods. Under such mediation, it would discuss the nature of different parties and whether they can ask for the legal services and legal help. The law enforcement department, they are legal to do this. In other words, under Singapore Convention on Mediation, it has this nature of legal law enforcement in this issue. This is the second issue to discuss. The second thing I'd like to discuss is the legal basis for cross-border enforcement. The involving parties, the settlement agreements should be directly enforced in the competent authority of a party state. They need to consult different methods if the original settlement cannot be achieved. And after mediation, this is international disputes, and we will have built such a mechanism under this SCM, the new mechanism. In it has written settlement agreements can be directly enforced in the competent authority of a party state in accordance with its rules of procedure and under the conditions laid down in the convention. I believe this is a critical revolution in this particular area, based on the leverage the law enforcement and international connection. This is a milestone to further develop this mechanism. In history, it is a milestone. There's one issue involved. The issue involved is what's the legal basis for cross-border enforcement? I'd like to explain in these 4 areas. The methods is very critical in solving international disputes. Involving parties can ask for the third-party independent services. It's very legal-friendly mechanism. So the agreement achieved represents the parties' idea and thoughts. the involved party, once the party decided which agreement to be settled, the relevant enforcement shall be conducted. And also mechanisms need to protect the enforcement of the process. The second part of the legal basis is we need to have practical needs. We have practical needs in commerce. We have such a practical needs in the international disputes, commercial disputes. And the third part of the legal basis is that I'd like to discuss is the specific benefits of resolving disputes. This will benefit different parties to manage international trades and to make it cost efficient for the government to mediate on such mediation services. If, according to the government's public speech, if we said we don't have a professional mechanism, this will not benefit the cost on legal lawsuits, and it will contribute no efforts, no benefits for solving international commercial disputes. So this will make sure that we have the global legal system regarding different countries. We would help everyone to have this organization and a mechanism in order to promote the international trade and the commercial activities. The third issue I'd like to discuss the conditions for cross-border enforcement. The conditions. No matter whether we obey the international regulations or the local regulations, we need to obey several conditions. Under SEC, we have specific SCM, we have specific conditions regulated in that particular contract or SCM. We have valid settlement agreements, such as these conditions set in that under SCM. We have two big categories. The first one is positive conditions. Another is the negative conditions. The positive conditions are four. There are four. The first one is that both parties have signed valid settlement agreement. And it means that it should obey the certain regulations, and we make sure it is valid. We need the second, that we need to have the evidence. We have the evidence that a settlement agreement resulted from mediation. We need to provide the evidence. The third condition is we need to have the official language of the party to the convention where relief is sought. The fourth condition is other requirements of the SCM have been complied with. So we can see this very positive, practical conditions under SCM. There are two more pessimistic or negative conditions. The first one is we cannot disobey the public policy of the local government. The second is the subject matter of the dispute is capable of settlement by mediation under the law of that party where relief is sought. So under SCM, the regulations are simple and clear. Between the countries that signed SCM, we need to obey these four conditions, already above all the conditions that we mentioned just now. And Another issue is that if we have to obey the additional conditions. My answer is no.
The SCM party should adhere to the clause written there. There's no exception. As to SCM's signatory and non-signatory or other non-parties commercial mediation execution conditions, currently, I would say there's no standard consensus. And based on each country's interest, we could refer to SCM's cross-border execution conditions for enforcement. But without the basis of international law, these countries, shall we enforce, and based on what conditions shall they execute other countries' commercial mediation settlement? This is some countries, other countries' discretion. Other country cannot step in. That's my third point. And third thing I would like to bring out is in terms of the settlement agreement cross-border enforcement procedures. Under SCM, there's no specific commercial mediation settlement agreements cross-border enforcement procedures. Instead, there it says for signatories, they should adhere to each country's procedures and under the conditions laid down in SCM to execute the agreement. That's saying the convention give discretion to each countries that are happy to improve their commercial mediation law. No matter if they are the member of SCM or not, they need to research on two things. First is they need to enact or improve their country's commercial mediation law. Second is based on second is on procedures for the enforcement of settlement agreement reached on the basis of mediation should be regulated. For their own country's commercial mediation, each country, they need to pay attention to commercial mediation law and to improve the mediation law to make it fuller, better, and more well-fledged. According to UN CITRO Model Law on International Commercial Mediation and Mediation Rules, actually, these two are an internationally recognized laws or rules. It's also our common wisdom for each country's improvement on their commercial mediation law. Actually, these two rules provide guidelines, and the rules written there provide grounds for each country to set up their own mediation law. Currently in China, in terms of civil or criminal law, we have our specific mediation laws, and we also have People's Mediation Law of the PRC, and also for right claim mediation law. However, I'd like to mention People's Mediation Law cannot replace commercial mediation law, because people's mediation cannot solve all the cases in commercial mediation, especially for large cases. Beyond people's mediation law, we need to have commercial mediation law. So for our country, we need to accelerate and improve our commercial mediation law. It could build a sound foundation for China characteristics law system and to provide flexibility, more convenient business operation environment. After SCM's launch in international arena, we must improve our mediation law. It cannot be waited. Several days ago, I had a discussion with Ms. Sun in Shanghai. We think in Shanghai, the mediation law can do something. For example, we could play a leading role in making our municipal mediation law. As to procedures for the enforcement of settlement agreement, I think it should be regulated. How to enforce them? What is a procedure? Actually, UN CITRO model law, there's no answer to these questions. And for each country, they have their own practices, which can hardly be copied to seek for legal help or remedies. So each country has their own practice. According to my personal research, I think, and also based on some countries' practice, I think for cross-border enforcement procedures, at least we should cover applications, acceptances, examinations, rulings on enforcement, issue of enforcement orders, etc. We should have clear regulation in these areas. So to sum up, international commercial mediations agreement when it comes to cross-border enforcement, I would say in China, including Hong Kong SAR, I think we should work on these, do some deeper research, because China is a signatory for SCM. So for this settlement agreement, once it comes to cross-border enforcement, we should work harder on this to facilitate Singapore Convention of Mediation in China's execution. Thank you so much. Thank you, Professor Huang. Thank you. Please be seated. And now, let's welcome Mr. Qin to talk about the second topic, that is enforcement of cross-border settlement agreement through international commercial mediation. Please, Mr. Chen. Mr. Zhang, Ms. Hu, Mr. Huang, distinguished guests, experts, ladies and gentlemen, good morning. So my topic today is to enforce of cross-border settlement agreements through international commercial mediation. Let's first take a look. When it comes to cross-border execution, what are the pain points and what is the SCM's status quo? So compared with international mediation, because the procedures are simple and also it fully respects the autonomy of the parties, it is cost-effective. That's why it is much more favored by companies. However, when it comes to pain points, it's actually the cross-border execution. Before SCM, international commercial mediation settlement faced long-term scrutiny, and the scrutiny lacked standards, and actually it hindered its own advantage. In China, US, Germany, settlement agreement is viewed as civil agreement. It has restrictions, but there's no enforcement. It must went through several processes to convert it into a legal instruments. In China, once we have a settlement, both parties could apply for a legal confirmation, and through the confirmation paper can it gain the legal enforcement. Before SCM, the cross-border enforcement, there were several ways to do this. First is to convert it into a legal instrument. And after the country's acknowledgement, can it be executed? For each country, when it comes to conversion, they need to adhere to its own country's system and legal mechanism. So there's no standard. So for cross-border enforcement restrictions, UN CITRAL made SCM. In 2019, August the 7th, we signed the agreement in Singapore, and in September 2020, the SCM took effect. As of last month, now we have 56 signatory countries, including 12 countries that have ratified the convention in their own countries, the latest one being Japan. So in SCM in 2024, April the 1st, it will take effect in Japan. Of course, UN CITRAL also launched international mediation example law and other supporting documents. We need to pay attention other than Japan. China, US, UK, and EU countries at the moment, they haven't approved or the agreement haven't took effect in their own country. In China, we were the first batch of these signatories. According to China's law at that time, the effectiveness of the SCM needed to be submitted to MPC because MPC hasn't approved it officially, so SCM hasn't taken effect in China just yet. We also notice that currently the Supreme Court is actively promoting SCM. In May 2023, the vice chairman for Supreme Court said on a convention, he actually mentioned one point, that is to accelerate systematic with Chinese characteristic and world-level international mediation solving mechanism to build China as a highland for mediation, especially commercial mediation, to help solve international legal disputes. Last month, Supreme Court issued a document. It says the Supreme Court is thinking about joining the SCM, and we are studying on the feasibility to improve our country's legal competitiveness. Given traditional litigation, when it comes to Belt and Road cases, it has its own restrictions. However, commercial mediation provides a fair platform to execute the cross-border settlement. It will be more trustworthy to ensure each party's legitimacy. It can meet the need of the market, and we look forward to see the SCM's improvement and effectiveness in China. Second part, I'd like to do a comparison between SCM and New York Convention. These two conventions actually, they are both aimed to regulate the cross-border enforcement of international commercial dispute resolution. However, SCM, when compared with NYC, under these 3 points, there are differences. First, SCM emphasizes on neutral third parties' participation, especially it required the plaintiff to provide the settlement agreement and evidence that the settlement agreement is based on. And when it comes to jurisdiction, it must provide the convention and its legal scope. So for each party, it has more supreme legitimacy and it's more legitimate. So when it comes to review and apply for remedies, it'll be easier. Secondly, SCM focuses more on jurisdictions. The first and the first under Section 3, Clause 1, when it comes to proceedings, it states very clearly about the application, and it actually reduces the conflict between Den Haag Agreement and New York Conventions. And for New York Convention, it is based on jurisdiction or application places, whereas SCM based on operation places. And for other disputes, for example, heritage, it also have covered that part. It's more open and inclusive. It can cater to more diverse needs under this complicated market. Third, in Singapore Convention, it simplified the remedy procedures. It's more expedient. Unlike New York Convention, we don't emphasize on the plaintiff himself. So when it comes to review and enforce remedies after examination, it is more simplified and efficient. Fourth, in Singapore Convention, it focus and highlight on the autonomy of the parties' intentions. In the agreement, we actually assess they only need to prove the settlement is legit and there won't be rejection of remedy. So it focuses on the propriety of the mediation's conduct. We actually focus and emphasize the legitimacy of the arbitration process that is listed in the New York Convention. Whereas in Singapore Convention, it focused on the propriety of the mediator's conduct, because in Singapore Convention, they have innovations in the above points. So they can apply for cross-border execution. It can improve the attractiveness of its commercial mediation. Thirdly, in China, when it comes to aligning with Singapore Convention, China faced several problems. In China, we still lack specific commercial mediation laws. Even if for the Supreme Court has its interpretation, and in some municipalities, they also have some rules, but these are more a concept level. So when it comes to settlement legislation, I think it's very imminent. It's also echoed with the earlier speaker's point, so I won't duplicate. But I'd like to emphasize when it comes to legislation, we need to more target it at commercial mediation and the settlement based on the following rules. First is to take the model law system, that is to have a law that is suitable for international and local law. Second, we need to clearly set out the definition to differentiate it with the people's law. Third is to confirm the execution court. Fourth is to confirm each party's remedy mechanism. Fifth is to protect the benefit of the third party. And in China, we lack our power, especially professional power, manpower, when it comes to commercial mediation. Just now we mentioned in China's mediation, he showed several data, but for me, I'd like to share this part. Since 2009 to 2023, in mainland China, we established the number of mediation organizations set up were 144, and a lot of them were established within the last 3 years. and only a handful of them have professional experts, mediators, I mean. So for mediators team, actually it quite differs. We have super qualified one, also have very weaker ones. In this regard, we need to improve the standard professional mediators, and we need to carry out in the following areas. First is to encourage the organization to set up their mediators' code of conduct. Second is to strengthen the training for mediators. The training should cover their academic background and also the mediation skills and techniques. Third is to promote mediator qualification accreditation. Four is to accelerate the standardized mediation organization. Internationally speaking, mediation organizations have achieved a large progress, and in China, we need to keep working on this. Fourth, SCMC, Shanghai Commercial Mediator Center, when it comes to improving credibility, we made several measures. First, strengthen the standardization of mediation organization to in line with Singapore Convention. Second is to we actually have already made some rules to be in line with Singapore Convention. Second is to improve the quality for commercial mediation to cater to the uprising demand, combined with Supreme Court civil rules and other documents. We launched commercial documents, including deposition and mediation agreement, etc. And during the mediation process, we need to adhere to confidentiality. We will apply these rules in all our mediation process or sections. Second is to improve the professional level of our mediation. SCMC collaborated with Shanghai Mediation Training Center to conduct training for mediators. And we also collaborated more with international players. For example, we invited James and other world-leading mediation centers to give training to our mediators to improve their international horizon, to improve their technique when it comes to international mediation. 2 days ago, we actually carried out a hiring and recruitment process. We hired 6 new mediators to join us. It will strengthen the cooperation between Hong Kong and China's cooperation. Thirdly is to deepen international cooperation and exchanges. SCMC collaborated with James, and we launched China-U.S. International Commerce Mechanism and also EU-China IP mediation organization. We established 11+11 China-U.S. mediator panel. Through panel or mock discussions or mock mediation, we trained each member. This year, SCMC, invited by EU IPO as the only Chinese mediation center, we attended European Union's Intellectual Property Force Convention. Around 70 countries, 700+ members attended the event. In order to strengthen the cooperation in Asia-Pacific region, on November 29, 2022, SCMC talked with Korea International Mediation Center and Tokyo Intimation Center. We attended the forum in Seoul, and it symbolizes the trilateral routine exchanges among our 3 countries. It was also recognized by International Energy organization, we had their support in order to further strengthen the IP protection since 2019 at CMC under the cooperation with China's Commerce Department and National IP Bureau. We set up our IP overseas services platforms in Germany, Tokyo, Spain to improve our overseas IP protection and assistance. It can help the enterprises to improve their awareness when it comes to intellectual property rights overseas. Lastly, it's about further strengthen Shanghai and Hong Kong's commercial mediation cooperation and exchanges. There are several suggestions. Hong Kong, as its center for shipping, commerce, finance, it serves as a very important window for China to go out, to be global. So for the Hong Kong's economy to keep going, keep shining, we need to improve and also solve commercial problems. So for DOJ in Hong Kong, have been dedicated to strengthen the international and also professional legal forces. We launched several agreements as well to strengthen our professionalism. And for Hong Kong and Shanghai, in terms of legal area, we have our own advantages. We are very committed to build a highland in Asia-Pacific region. We have two suggestions. First is to center around central China government's with aspiration to set Hong Kong as an international mediation. We'd like to propose mediation first concept to raise the market's awareness to commerce mediation. And we would like to strengthen the exchange between Hong Kong and Shanghai. Through joint mediation and joint training, we hope we could improve our service to build a world-leading and influential China commercial mediation brand. I won't delve into this. Thank you so much for your attention. Thank you. Thank you, Mr. Chen, for your insights. Now, let's invite Mr. Tao to share his insights.
用英文講啊，如果你唔介意。
My speech will be delivered in English. My slides are not ready, so could you wait for a minute?
好，唔該晒。咁啊。First of all, thank you very much for inviting me in Department of Justice. And also I'd like to thank, for example, the Vice Chief Judge of the Supreme People's Court, as also the Chairman of the Shanghai Commercial Mediation Center, as well as the Vice President of the China Law Society, as well as the Vice Chairman of the Shanghai Commercial Mediation Center. Thank you very much. Now, some of my previous speakers have already covered quite a lot about international enforcement through mediation. So I'm going to go through this very quickly. Now, I'm going to focus on three areas. One is the countries signing the Singapore Convention. Okay, this is a very important convention, and I think I give credit to the Singapore government for taking this forward, and also our Chinese counterparts for actually participating throughout the whole process. Now, the criteria, I think Professor Wang mentioned about the criteria, which I will not go into in detail. But I'm going to focus on the challenges in terms of, for example, international mediation settlement agreements in terms of enforcement. Now, the first one I would like to say is mediation taking off? When I first came out to become a barrister 6 years ago, I thought I'll be doing 100% mediation, 0 litigation, 0 arbitration. As of today, I'm doing 80% arbitration, maybe 10% litigation, and only 10% mediation. So why is that? The answer is because people's emotions come into play. Because people feel, for example, that they have to have their day in court or arbitration. But when they actually win, great. But if they lose, they suddenly complain about the fees. They complain no justice, and so forth. So there has to be some cultural change to change people's mindset that this mediation element is a good thing for society. Because not everyone has so much money to spend on litigation or arbitration. You need to have a forum for access to justice. That's very important. If not, people will complain about justice throughout the years. Now, as Professor Wang said early on, there are 56 countries, and also David have signed, in a way, signed the Singapore Convention, and 12 have ratified it. Now, I want to focus on Hong Kong. Now, I might mention about Macau. This is very important. People also assume, oh, we can enforce this because Hong Kong can sign this convention. Hong Kong is not a state. We must emphasize that. Hong Kong is a state within a state, if you want to call that. Hong Kong is a special administrative region of the People's Republic of China. So henceforth, we cannot be a signatory to the Singapore Mediation Convention. Now, only China can be it. But China can apply to the United Nations to say that Hong Kong and Macau could be a signatory to the convention on its own accord if need be. So this is where we need our friends in mainland China and also Department of Justice to help us in terms of having this process going through. Now, this is a good thing in terms of international mediation settlement agreements. But what about domestic? Now, as you all know, going back to basic contract law, okay, there are three ways to do a contract. One is by verbal, one is by conduct, and one is by written. Now, most of the people in domestic situations do contracts by verbal. So how do we address this? This is something that we have to grapple with. Going forward, in terms of, for example, settlement of mediation settlement agreements in a domestic environment, should we have some kind of enforcement regime? I raise my hand and say yes. Not just the international element, but also domestic element, because some cases are more suitable to go to mediation. Now, likewise in Macau, if we can do for Hong Kong, we must do for our friends in Macau. Because at the end of the day, we have to be fair. So Macau is also developing as a dispute resolution hub to the European and also South American friends who do a lot of disputes involving those areas. Now, the requirements, okay? The requirements, as Professor Wang mentioned earlier on, in terms of, I just want to focus on one point. One point is, number one, the mediator's signature on the settlement agreement. Now, just bearing in mind, a contract, if a person signs on an agreement, if I'm unhappy, I might sue the other side, but also I might sue the mediator as well. So you have to be a bit careful. So if you look at the word very carefully, such as, at the very beginning, doesn't mean that you have to sign it. Okay, you don't have to sign it as a mediator. But some mediators assume that, oh, I have to sign on this settlement agreement. It's only an example. Okay, an example means that you can do that. Now, most of the time, people will try to actually have an agreement to mediate. In Hong Kong, we have that, to show that the mediation took place. Now, another one is I want to highlight is 1A, and this is the grounds for refusing to grant relief. A party to the settlement agreement was under some incapacity. Okay? Now, we have a lot of these cases whereby people say that, oh, I don't know how to read the contract. It's in Chinese. I only read English. Or someone else says, oh, I only can read basically English. I can't read Chinese. So they use a lot of these kind of things to get out of the case. So the chances are you have to make sure the person has capacity. Okay, that's very important. Another one is, we talked about here, is about, for example, the modification of law. I'm not going to go through that, so that's very quickly. Move on to the next one. Now, the one in red, I just want to focus on that. The one in red, it says that there was a serious breach by the mediator of standards applicable to the mediator or the mediation, without which breach that party would not have entered into the settlement agreement. Now, this is very important because as mediators, we have to have some term called ethical standards, procedures that we must follow, okay? This is something that's very important. Now, this is something that we must develop going forward. Now, in arbitration, we do have what we call the code of, for example, the conflict of interest, the International Bar Association has developed. So this is something that maybe our Chinese friends from mainland China and Hong Kong and Macau can work together to develop a code for cross-border mediators in terms of ethics. This is very important because we need to show some trust. Because when it comes down to mediation, people believe in trust. Trust is very important. So if the trust is broken, that is a very serious consequences, and henceforth, we will not get the mediation settled. Now, if you look at most of the cases, I've looked at the Department of Justice and also the Judiciary website over the years, a number of cases going to mediation has dropped. Why is that? The answer is because, not because we don't want to go to mediation, it's because economic situations. People do not have the money. They just sit down and negotiate, okay, and try to get out of it. It's not because mediation is not popular. This is something I want to emphasize. Now, of course, Professor Wang and David mentioned about, for example, public policy and issues. Of course, we need to have some reservations about public policy in our countries and so forth. I won't mention that. Now, the challenges. The direct enforcement. Now, Hong Kong is not a signatory to the convention at this moment in time. Now, how can we do this? How can we make sure, for example, things can actually progress? Coming back to the contract, okay, as Professor Wang about the freedom of contract. You come into contract, what will happen is both parties will sign a contract. In the contract, there is a dispute resolution provision, which will call for negotiation, mediation, or arbitration. So then you start off with, for example, arbitration. Then if both parties agree to go into a mediation, they can. And in Hong Kong, under our law, which our government is very sort of pushing for, and actually came into fruition, I think I give them credit for that. In terms of, for example, having the arbitrator convert to become a mediator, and if it's settled, clearly then you can convert that into a consent award, which is enforceable like an arbitration award. So we do have some kind of mechanism in place in Hong Kong, but the problem is we have to start arbitration first, okay? Now, some people, when you mention arbitration, they say, oh, very long, takes a long time, very expensive, and so forth. So that's why the Singapore Mediation Convention is a good thing, that I believe. Now, non-reciprocal nature, okay? Our friends from Taiwan, they're not signatories to the Singapore Mediation Convention. So we need to cater for situations because we do have cross-border between Taiwan investors in mainland China and in Hong Kong. So we need to have some kind of reciprocal recognition in terms of how we enforce each other's mediation settlement agreements as well. This is something that we should be doing because at the end of the day, this is something to encourage international trade as well as friendship going forward. Now, many countries have many definitions of mediation, okay? Now, that's one thing that we need to grapple with. How do we unify this? Now, our law in Hong Kong, the Mediation Ordinance, Chapter 620, has a definition of mediation, where our Department of Justice has spent a long time trying to look at different countries to come up with the right definition for Hong Kong. So I think this is something that we need to look at as well. Now, confidentiality of mediation. Now, this is something that people mostly talk about. Why? Simply because we go to mediation, we more want our things to be closed door. We don't want the whole world to know about it. Because at the end of the day, it's something that we believe is to our own personal interest, and we don't want everyone to know. But unfortunately, when you go to enforcement stage, we don't know. No one's perfect. Maybe some judge will suddenly disclose all the documents. Then we have a problem. So there must be some guidelines. So I think the judiciary, working in different countries, the 52 countries who've signed it, maybe have to come together and have a code for judicial assistance in terms of when enforcements come into play, what do we do with this mediation settlement agreement? Do we disclose it or do we not disclose it? How do we handle it? That's very important. Another one is the court's involvement in enforcing this. This is very important. I think most judges, when they look at this, they always say, okay, this is something that I have to look very carefully about because this is a settlement between two parties. But that's why we need to have more education, telling people that, for example, this is a good thing, so that the judiciary, when they look at these kind of documents who come to their court, they'll say that this is something that I can enforce and with confidence. That's something that we need to give some kind of education to the different judiciary to tell them that this is a new thing happening because society needs it. Now, the terms of enforcement, that's another thing we have to look at. For example, specific performance, we might not be able to order from a court's point of view. So how do we address this, okay? Evidence and documentation. Okay, people talk about the accuracy. So sometimes people talk about the document's fake, it's fraud. and so forth. How do we address this as well? What kind of situations, what needs, checks and balances do we have to put into place? Now, of course, we mentioned about cultural languages differences earlier on. Now, another one is, I'm sure you've all heard of the case whereby arbitrators conducted an arbitration, but there was no dispute, and it was just about money laundering. So we want to prevent this from happening, because if money laundering or mediation is used as money laundering process, then basically people will have no confidence. So there has to be some checks and balances in place. And of course, it's between two parties. In Hong Kong, we have a third parties rights ordinance. So the chances are, or sometimes called the contract third parties rights ordinance. And if a third party comes in, how do we address that? Okay, is it related to this person? Is it not related to this person? How do you address that going forward? So on those, you can see, ladies and gentlemen, there are quite a few challenges. Now, the Singapore Mediation Convention might be a good thing, but at the end of the day, we need to have some guidance, some notes to assist not just mediators, not just parties, also judiciary, as well as people who are interested in this area to show that there is some kind of confidence in using this process. On this note, I believe, for example, we have a lot of work to do, and I'm sure with our counterparts in mainland China and in Hong Kong, we can actually do a lot of things together to actually benefit society. Thank you very much.
Thank you, Dr. To, for sharing his valuable experience in the enforcement of mediation agreement. 接着下来，我们邀请大家一起观看马杰。
The following, I would like to invite everyone to check Dr. Marcello's insights on the big screen.
Gentlemen, let me start by saying how delighted I am to be with you today. Certainly, I would have preferred to give this speech in vivo in Hong Kong, but unfortunately, commitments previously made kept us physically apart. I'm currently talking to you from Spain, where I have recorded the present speech. I'm most grateful for the invitation that SCMC and its director, Mrs. Zhang, have extended to me to participate to this most interesting Shanghai-Hong Kong Commercial Mediation Forum. While we recognize and appreciate the many advantages of settling disputes through mediation, it is crucial to acknowledge the enforcement-related problems when one of the parties involved fails to comply. Mediation's strength lies in its collaborative, voluntary nature, but we must ensure that its outcomes are equally robust. It's not just about reaching an agreement, it's about guaranteeing that the agreement stands firm even if a party falters. Settlement agreements resulting from a successful cross-border mediation have traditionally no better legal status than any other contract and are generally enforceable under standard contract principles. Failure to comply with the agreed terms will be a breach of contract upon which the injured party may bring legal proceedings in accordance with local law. This is where enforcement mechanisms become vital. We can enhance the effectiveness of mediation by providing to the parties clear and reliable pathways to enforce their agreements. Businesses may be more inclined to choose international commercial mediation over international commercial arbitration and litigation if mediation agreements and settlement agreements were as easily enforceable as arbitration agreements and arbitral awards. The European Union has always been committed to promoting peaceful dispute resolution and encouraging the use of alternative methods like mediation in international commerce. In contrast to what happens with regard to international commercial arbitration, an area on which the European Union decided not to regulate, the European institutions have actively engaged in shaping the landscape of mediation. In the European Union, the enforcement of cross-border settlement agreements resulting from international commercial mediation is guided by the Mediation Directive adopted by the Council in 2008. A directive which promotes the enforceability of mediated agreements by setting a framework for cross-border recognition and enforcement. The EU Mediation Directive does not envisage, however, direct enforceability of mediated settlement agreements. Under Article 6 of the EU Mediation Directive, a written agreement resulting from mediation shall be granted enforcing effect in a member state if all parties involved in the dispute have given their explicit consent to the enforcement of the mediated settlement agreement, unless either the content of that agreement is contrary to the law of the member state where the request is made, or the law of the member state does not provide for its enforceability. This may lead to the mediated settlement agreement being integrated into a judgment or authentic instrument, which in turn could be subject to the relevant EU provisions on the recognition and enforcement of judgments in civil and commercial matters, such as the so-called Brussels regulation. These provisions apply to cross-border enforcement, namely enforcement from a member state to another, and presupposes the enforceability of the agreement resulting from mediation in an EU country. Consequently, a lot depends on the law of the initial country, which normally is the country where the agreement was made. This situation leads to different assessments and divergent approaches to the effectiveness of the agreement resulting from mediation and its cross-border enforcing effect. For instance, the comparison between member states shows that within the European judicial area there are some differences in the requirements for cross-border mediated settlement agreements to be declared enforceable by a court or by a notary. In particular, in Germany, the conferral of enforcement is always subject to the consent, whether express or implied, of all parties involved in the settlement. In Italy, on the other hand, the legislature has adopted a more favorable position by simply requiring the consent of one of the parties to the settlement. Furthermore, the 2004 EU regulation that created a European enrollment order for uncontested claims may also offer solid foundation, solid grounds for enforcing mediation settlement agreements once they have been declared enforceable. The regulation is applicable to all European Union member states with the exception of Denmark. The European Enforcement Order enables the enforcement of judgments, court settlements, or authentic instruments related to uncontested claims across all member states without the need of intermediary procedures. A cross-border mediated agreement involving a pecuniary claim shall be made enforceable in the state of origin and subsequently enforced in another EU state by virtue of Article 24 and Article 25 of the regulation. This means that a mediated agreement certified as a European enforcement order in the member state where it was concluded could be directly enforced in other EU member states, provided that it is enforceable in the country of origin and without the need to use the exequatur mechanism. The existence of such an instrument within the European territory favors the uniform application of Article 6 of the previously mentioned EU directive. I may not wrap up my speech without addressing the agreement on a unified patent court, which established a specialized international jurisdiction to handle cross-border disputes related to European patents. The agreement entered into force in June of this year in 17 European countries. It establishes an enforcement mechanism that grants mediated settlements reached through the services of the mediation center attached to the Unified Court the status of directly enforceable court decisions by a court confirmation. In conclusion, in terms of certainty and simplicity of enforcement requirements and procedure, the existing methods of enforcing international mediated settlement agreements in Europe lag significantly behind the enforcement framework provided by the Singapore Convention on Mediation. The EU was closely involved in the treaty negotiations, but to date has not signed it. So far, neither the European Parliament nor the European Council have taken a position on this matter. Equally, no EU member state has acceded to or at least signed the Singapore Convention. I believe that EU's accession to the Singapore Convention would be a commendable step, and in any case, one that deserves serious consideration and debate. European business will have greater certainty in resolving cross-border disputes through mediation, as the Singapore Convention establishes a more effective means for mediated outcomes to be enforced. It can provide significant incentives to European corporations that wish to opt for mediation, in particular in their trade relations with non-European partners such as China. Thank you very much for your attention.
Thank you, Dr. Machellos. 我相信各位朋友会同意我的看。
I believe that everyone will believe my opinion that from the dear guests, we learned so many things from the mediation and settled agreements, these insightful knowledge. Now we have the question and answer session. Let's have a look on what kind of questions here. There is one question about how to, if the settlement agreement is enforced, the enforcement party is organization that protected by the local government. So what kind of rules or regulation items should be included in this agreement in order to make sure it's smooth enforcement? If after the settlement, if after the mediation we have reached this agreement and this agreement can be enforced, if this one of the parties is a sovereign party, and this will involve whether the country has allowed this. So, if this is by nature is a commercial action, whether we need to consider whether the government would like to involve in this mediation. And actually, after the mediation, we understand that both parties would like to reach such mediation, but as is involved, the country's benefits or own money or capital. So this actually a little bit complicated. One government should consider the other government or country's capital, but it cannot make sure that the capital can be enforced or can be dealt. So it needs to consider whether this case is related to commercial activities. We need to consider the previous cases, like whether we, according to certain regulations, actually we have certain agreement that we can obey, and in such case we can actually do this. But we need to look into whether it's a commercial action. For its assets enforcement, we need to consider the current regulations, whether it can be enforced. Thank you very much, Dr. Huang's answer. Another question. According to the mainland China's basic laws, what kind of practical obstacles have been faced nowadays? Sorry, can you repeat the question?
In a country under continental law jurisdiction to enforce the common law agreement, will there be any challenges? I think it depends. It varies from case to case. Sometimes the challenges happened with the language, whether there is problem with interpretation. For example, whether the procedure is applicable. And you know, when it comes to mediation, even that between mainland and Hong Kong can be vastly different. So people may not come to accept the mediation. Thank you.
另外有一个问题啊。
Another question is related to Hong Kong's most recent policy actions just published. In this year, Hong Kong plan to further promote mediation services. The fee involved also is discussed. The government would like to further promote to establish the mechanism to solve the relevant issues. And in Hong Kong's legal requirements, we would like to encourage the relevant business organizations to get involved in this, and we need to put in the contract to mark this specific issue. What are the challenges and opportunities in this? Can you repeat? Okay.
Okay, in the policy address this year, to further promote the mediation culture, the mediation fees are generally lower than arbitration or lawsuits, and the government will promote and further establish a mediation-friendly system, and certain terms will be applied, and private institutions will be encouraged to adopt similar terms. And when it comes to the application of such general terms to the contract, are there any challenges or opportunities? Well, I'm in a position to make comment on this area because there are a lot of lawyers at present, but the government is right in telling the people that there are more than one channel to resolve disputes. Well, people, if they don't feel they can get a good solution to their dispute under the current legal system, they'll get a sense of unfairness. So mediation provides an equitable access to many in the society, giving them a chance to let them voice their concerns. But does mediation apply to all kinds of contracts? No, not necessarily. If you are using a Panadol to treat your headache, and the doctor keeps prescribing you the same Panadol to all kinds of aches or pains throughout your body, and you may want to consider another doctor. A legal professional may come to you and tell you, okay, your case may be able to adopt a mediation for your contract. If you don't want to go to court, you can resort to mediation in your case. You know, in Hong Kong, there are practice directions, but oftentimes it's usually the government taking the initiative. But on the other hand, if is the civil bodies taking the initiative, and that will be better.
我们再次感谢各位讲者跟我们分享他们在执行和解协议方面的宝贵经验。最后，预祝今天的研讨会圆满成功，期待不久以后再次跟大家见面。谢谢大家。
感謝各位，感謝我們各位的講者主持，請留步，係啦，請留步，讓我們來個合影。對，我們站起來，然後他前一步來個合影，我哋一齊企起身去前面一齊合照。係啦，我哋來記錄這個時刻。看一下我們大會攝影師，請舉手。對。非常感謝，我們再來一個掌聲。非常感謝各位，請就座，請就座。在展開下一個環節之前，我們有一個休息的時間。下一個主題論壇會在11點05分的時候開始。歡迎各位到會議廳外指定的位置去享用咖啡、茶點，並於論壇前回到會議廳。另外，請各位把握首次在香港法律周期間特設的香港、澳門及大灣區內地9個城市的法律服務新發展和機遇的專題展台。專題展台設於會議廳對面的 N206-208 會議室，歡迎各位到場參觀。各位在論壇任何時間離開會議廳，請帶同你的貴重物品。線上參與的同事們，我們11點05分再見，謝謝。 位嘉宾，我们的论坛将于几分钟后开始，请大家尽快就座。谢谢。欢迎各位回到论坛的第二个环节，主题是积极构建专业化、国际化上市调解培训机制。
of mediation and developing a mechanism for international commercial mediation training. We're happy to have Mr. Drew here. Let's welcome him to the stage. And let's welcome Professor Leung, Ms. Wei Zhang, Mr. Winston Siu, and Mr. Yu Ting-ko, MH, as our guests. Welcome, Mr. Zhu. Distinguished guests, just now we had our first discussion and everyone had their insights sharing, which are inspiring, and we look forward to our second session. We have 4 guests here, and I'm looking forward to their sharing and insights. First, let me introduce them to you all. First is Hong Kong Mediation Accreditation Association Limited, former Vice Chairman, Professor Leung Hing Fong. And second guest is Director of Shanghai Commercial Mediation Center, President of Kaishan Mediator Academy, Ms. Wei Zhang. Third guest is former Chairperson, Hong Kong Mediation Council Limited, Mr. Winston Siu. Our fourth guest is Founder Director of Asia Conflict Resolution Institute, Adjunct Professor of the Department of Law of HKU and the School of Law of City U, Mr. Yu Ting-kwok, MH. Okay, without further ado, first, let's welcome Hong Kong Mediation Accreditation Association Limited, former Vice Chairman, Professor Leung. His topic is how to provide systematic commercial training to commercial entities and agents. Let's welcome. Ladies and gentlemen, guests, similar to the previous session, my challenge is, this is the first time I speak in Mandarin. I have very special Hong Kong flavor Mandarin, and it may seem quite entertaining to you. So my topic today is to provide systematic training for commercial entities and agents. So today's content, more of a sharing from a training practitioner, because for me, I work for a quite leading organization in terms of Mediation Accreditation Association. I was the former vice chairman. So I have to say, perhaps today the content is not from their standpoint, more of a personal sharing. When I say training in Hong Kong, in order to host these trainings, what are the points to notice? I think the purpose of the training should be clearly stated, because in Hong Kong, it's a mainstream. Same in mainland China. The mainstream training is more for mediators. But here, we're more for commercial entities and agents. So the purpose must be clearly stated. It's not designed for training mediators, but for users, user-oriented. The focus of the course content ranges from macro to mediation techniques. That's one. And for training, it's more for the purpose of assessment. So the thing we need to pay attention is to get a high score. That's our assessment point. But here, it's more for practicality, not for the purpose of assessment. It's purely for practicality, not for evaluation. We also have other trainings we need to clearly state out the deliverables after the training. For example, after the training, they can have a preliminary understanding of different modes of mediation. In Hong Kong, training is based on a certain mode of mediation. That is what we say, facilitating mediation. But when it comes to international commercial mediation, we have different participants from all walks of life. So there's chance that we may have different mode. For example, evaluation mediation. We have a task force, and they have very strong understanding in this regard. So we can't treat it as other facilitative training. We also need to consider other modes. Another deliverable is after participating in the training, commercial entities or agents will have the initial knowledge or skills to participate in mediation. And for training content, we have a holistic strategic view. We need to have initial macro concepts, including, for example, Hong Kong has a large organization, a large structure designed for mediation. That's what I work for. It's called Hong Kong Mediation Accreditation Association Limited, because the name is too long.
Which is short for Mediation Association. So it set up. It functions as the leader for this issue, and it will have like certain mechanism to make sure that we obey the rules. We will have some training on the targeted relevant party. But for the long run, no matter whether it's Hong Kong or mainland China, we should have an organization to offer a standard and trainings in this area. Another issue is that we need to provide the training mechanism. Let me introduce the mechanism here in Hong Kong. We have the process of training, and we have the test session. We have the trainer, we have the trainees, etc. During different seasons, they need to pass certain requirements. They have training requirement, we have experience requirement, including whether they are specialized enough to conduct activities in this area. And we have chief trainer, and we have general trainer. They have the training goals and rules in training. So this system, in this area, in this training, we can learn from the current system. Also, from the more macro perspective, according to Hong Kong's regulations and rules, laws and rules, because in Hong Kong, we have the legal independence, uniqueness in Hong Kong. We have the legal enforcement issue. And this issue relies on a reliable, independent party to make sure that we have the right standard. In general, we need to have an overall understanding of Hong Kong's training mechanism. Because in the mainstream mediation services in Hong Kong, we have this goal to facilitate the mediations. The basis is to focus on the agent's focus on the party's attention and his or her needs. In Hong Kong, especially in construction area, in so many cases, the workers in this industry, during this mediation, they believe that the mediation cannot make their voice heard. However, in Hong Kong's system, their voice can be heard is actually allowed. But we will try to encourage them to voice their opinions. We need to introduce the procedures, educate them how to do this. And also, there's another issue, how to select the relevant mediator. We have some experienced lawyers to provide their professional opinions. If the party is confirmed to participate, to get engaged in this mediation, if a lawyer will participate in the mediation, we need to set different roles for the mediator as well as the participants from the involved organization, like the board member of the company. So we need to make sure they play the right roles, and so that we can contribute to the overall settlement or achievement of this mediation. We need to make sure beforehand what kind of role each party plays, and this is critical to the issue. Also, we need to have full permission from different parties. They'd like to sign agreement if reached. Also, we'd like to be very prudent in choosing the location of the agreement settled. In Hong Kong, we have different platform. We have an online platform. It's called Mediation Center, and this can provide such services. In order to make sure that we have the efficiency and effectiveness of the mediation services. About SCM, we all know that in Hong Kong, we might need to wait for a relatively long time for it to be conducted in Hong Kong. So we need to practice according to current regulations. We have specific details that in Hong Kong, we might mistakenly mess with basic laws versus the mediation service regulations. This is the issue we need to pay attention. Another thing that we need to pay attention is that in Hong Kong, both Chinese and English are legal official languages. So we have this advantage in the culture and language side. In previous cases, we have different regulations in property management and in construction industry. We have previous cases that we can take reference to, and this is also another benefit that we have. This is another advantage that we have besides languages. Another thing that is very unique for Hong Kong's training mechanisms is that participants' opinions or feelings are valued, and their voice can be heard. Let me jump into the emphasis I need to mention. We need to have a mechanism and a system in order to provide a good platform for Hong Kong. We need to have a systematic training in this area. no matter for domestic experiences or international experiences, we need to learn from both sides and be insightful. Thank you. Thank you, Mr. Liang, for your speech. For Professor Liang's speech, and Mr. Liang has mentioned about the different parties' needs and requirements. And regarding the lawyers and professionals and involved in the mediation services, thank you for sharing. We have actually in Shanghai similar process, but we focus more on the mediator's performance. And the lawyer's role is also paid much attention. So this is quite a little bit different than in Hong Kong's current conduction. Thank you for sharing. Now let's hear Shanghai's insights in this regarding this issue. Let's invite the next speaker, Mrs. Wei Zhang, Director of Shanghai Commercial Mediation Center, President of Hong Kaishang Mediator Academy, to provide her insights. Thank you. Thank you for your host, and thank you for the Hong Kong colleagues here in Hong Kong on the stage, and happy to see Professor Liang and also our teacher Xiang from the first forum. We have cooperated together continuously until now. Today is the 6th forum. So every 2 years we have one forum. So we have already walked 12 years in total. I'm delighted to see the old pals here on the stage. That means that this is a continuous process. And thank you very much for your insightful opinions. I'd like to share with you the ability. The topic for me today is build professionalism. Internationalization is very critical in Shanghai, and I'll introduce the Shanghai's experience in commercial mediation training mechanism. The mediator's expertise will directly influence the experience of the relevant parties, and this means this is critical in a brand and reputation building of the mediation. Not only we need to take a look at whether our experts have the relative knowledge and the skill sets to conduct the mediation. Before, we'll focus on its legal background. However, we'd likely to neglect to further train its expertise and skill sets. So in recent years, we have conducted several things in order to help our experts to leverage their professional skills. Starting from the 6th of this month, we have 169 members on the board, and now we very delighted to welcome 6 more Hong Kong mediators to join our organization, so they can all conduct in more than 2 languages in their actual work. And they will also show.
And secondly is to build the training mechanism. It is the guarantee for the smooth function of an organization. I remember before at Supreme Court, that's where Officer Jiang worked for. They mentioned for mediators' proficiency training, whether it was already included in SEMC. At that time, we were quite puzzled. So under the connection of Supreme Court, we worked with Jiaotong University in Shanghai, and we established Kaisheng. After training, the mediator can not only have a more professional understanding, but when it comes to mediation techniques, they can also reach a very high level to cater or encounter the much more complicated commerce to solve issues. So solving a good mechanism is also a standard to measure an organization's international capability. And third, SCMC always attaches great importance to enhance our mediation service, no matter the case is large or small. But we think the service actually can be categorized into different levels. What I mean is, first, mediators, when it comes to selection, we have very strict criteria. After 10 plus years, till now, there's no one mediator who was accused of unprofessional or complaint. So you can see our team, how professional and how qualified we are. So that is one in terms of mediator selection. And other than having a leading role in professional area, our mediators is also exclusive, exclusive. So our mediators cannot work in other organization except for nonprofit organizations. Otherwise, it will dilute our quality, that is our character. And secondly, there's a system for commercial mediator training. So SCMC, when it comes to training, from the very start till now, we attach great importance to the training. We have internal mediation training, and also we hire overseas world-class mediation organizations to collaborate with us to train our mediators. Pre-COVID, U.S. James came to Shanghai every year for training. We also provide other international mediation organization classes. We have already formed a norm. And next is international training activities. All the trainings and activities can provide each mediator with an opportunity. For example, we will vote or select some mediator for Waffles mediator or to serve as James mediator. We also served as UN mediation teams mediator. So the criteria is whether we can in line with international organizations, if they can accept our mediators. That's the criteria. So after strict selection, our mediators can involve into these international organizations' activities. That shows our training is correct, on the right track. So recently, we have been working with CETA training course. CETA from UK is also world-class. We had a very pleasant collaboration. Other than that, we also actively encourage our mediators to attend talent training class to share their insights. That's also promoting our platform and mechanism. We also like to popularize commerce mediation. There are two legs. First is the organization's self-strength. Second is for commerce mediators target our customers. We need to let more people know that commerce mediation is for win-win situation. It is the best choice when it comes to dispute resolution. We have insisted for 6 years to promote our commerce mediator. We have commerce mediator weeks. And we also go to universities to popularize mediation, and these are well received. We also collaborated with Hong Kong colleagues and partners. In 2016, as invited by DOJ, we trained university students here, and this year they invited us again to attend Hong Kong UK class training. So this mutual understanding and exchange also provide a very important platform for us to be more internationalized. Due to time restriction, I'd like to touch upon another point. We'd like to, through the 6th Shanghai-Hong Kong Mediation Week, we hope going forward, Shanghai and Hong Kong, when it comes to mediation training and organization cases collaboration, the legal week can serve as a good platform for us to exchange much better. And we had a Jiangsu Commerce Chamber of Commerce. We had a exchange there, and we hope through these professional exchanges we could combine our social and commercial team for the influential organization or Chamber of Commerce in Hong Kong. We hope we could provide our service to them. Thank you so much. Just right in time. I caught the last minute. Okay, thank you so much for your insight. Actually, SCMC to organization mechanism or mediator training, we have very strict criteria for mediator selection. So where is our intangible asset? There actually are mediators. So if the mediator's quality affects a lot, means a lot. Thank you so much, Ms. Zhang. So now, let's welcome Director of Asia Conflict Resolute Institute, adjunct professor of the Department of Law of Hong Kong U and the School of Law of City U, Mr. Yu Ting Kwok. Let's welcome. Mr. Yu said he'd like to speak in Cantonese, so if you need any help, please switch the channel. Put on your headset now.
Likely because of feng shui or karma, and that speaker, the speaker speaking on the final row, usually speaks the worst Mandarin, so I believe there's a reason why I was assigned that seat. Thank you very much, and would you like to wear your headset? I'm going to commence my sharing. And Vice Judge Hu Fang and Mr. Sun Jingping, dear guests, online and offline, I'm very honored to have this opportunity to be here. I believe this invitation itself is a mistake. The organizer was hoping to invite Secretary for Justice Lam Ting Kwok, and mistakenly they have invited me, Yu Ting Kwok, to be here. And so by this mistake, I'm here with you. Now, this theme is building a professionally internationalized mediation and training. Now I'm going to tell you about the certification regime and mediation training. We're talking about commercial disputes, not household or family disputes. And my sharing is not related to my affiliated institutions such as the mediation organization or Hong Kong University or the City University. I hope that through this sharing and by hearing from you, your feedback, your comment, we can do better here in Hong Kong. In 2009, April the 2nd, the Civil Judicial reform was implemented in Hong Kong. Several purposes have been outlined, including a facilitative settlement. The DOJ has done a lot of work in this regard. And there is a panel report released in February 2010. And 48 suggestions have been outlined. One of them was the certification company was to be set up. It was set up in 2018, and it had been nearly over 10 years. And Senior Counsel Yun Kok-keung, who is heading the Hong Kong Mediation and Accreditation Associates Limited, or HKMAAL, and Mr. Yun has done a lot of work supporting it in its work of establishing a local mediation accreditation regime. Our challenge is, if we talk about improvement or enhancement, and you don't mistake it for me saying there are a lot of shortcomings or flaws in the work. But when I say enhancement or improvement, I would like to draw attention to our status quo, and we have a practitioner an ordinance concerning legal professionals, but not mediation professionals. So you don't have to go to HKMAAL for certified professionals. For example, an arbitration. You don't have to find arbitration professionals under the official organization.
但係另外一方面嚟講，規管強化我哋嘅水平嘅時候呢，我哋可能要做得更好。行政長官喺2023年，即係今年嘅施政報告第77段裏邊咁嘅講法，政府需要強化體制，包括調解專業嘅認證同埋紀律事宜制度。換句説話嚟講，我哋都係適當嘅時間要想一想我哋嘅前路啦。好。嗱，香港嘅狀態係咁嘅。香港咧喺調評會底下咧有綜合調解員同埋呢個家事調解員。頭先講咗，我哋今日唔講家事調解員。綜合調解員咧可以講好多處理好多紛爭啦，包括但不限於一個商事嘅工商意外侵權行為、知識產權等等都可以嘅。我哋依家就要諗一諗，就話我哋譬如同上海對接，或者喺呢個新加坡調解公約裏邊咧係講 commercial mediation 商事調解嘅時候，咁我哋喺香港發展我哋嘅調解嘅時候，我哋需唔需要更加專業化，有一個名冊係呢個商事調解嘅？呢方面咧，我哋大家都要諗一諗。好處就係話我哋可以更加專業化，但係另外嚟講嘅時候，抑或我哋讓綜合調解員自己去走專門化，即係換句説話嚟講，唔規管佢。但係如果你想做多啲商事嘅時候咧，就做多啲。嗱，喺我哋嘅認證制度裏邊咧，只有綜合調解員，冇話分級制嘅。換句話來説，冇1級、2級、3級或者高級、資深等等嘅制度嘅。嗱，將大家咧，如果要去考慮前路嘅時候咧，呢個咧都係大家可以要考慮嘅地方。嗱，如果我哋分咗等級嘅時候，可能一啲所謂係比較年輕啦，或者係冇經驗嘅人咧，可能係好難去攞到調解嘅工作，提供到調解服務，因為人人都會揾晒嗰啲高級啊、資深嗰啲。但係我哋唔分制度嘅時候，又如何讓使用服務者知道佢哋嘅質素呢？因為畢竟啊，調解係一個閉門嘅工作，所以嚟講咧就話好多時咧，調解員實際嗰個工作咧係做得好唔好咧，都係用個口傳嘅啫。因為喺領英裏邊啊，人人都可以影幅相，人人都可以話自己係調解嘅教父。咁究竟做得好唔好咧？呢個係一個挑戰嚟嘅。 所以嚟講就話，當我哋香港向前，或者我哋將我哋嘅經驗分享俾大家嘅時候，大家都要考慮下喺調解制度裏邊是否分級制，或者是否專門化。呢一點啊，我相信啊，我哋大家都要努力咧去考慮一下嘅。我哋依家頭先梁教授都講咗少少，依家喺香港嗰個培訓方面咧，重點就係一個技巧同埋一個程序。咁嘅時候咧，我哋就用一個叫做促進式調解。咁嘅時候咧，亦都係架構住或者勾住啦一個咧係以呢個關注為基礎嘅協商嘅。咁當我哋走出香港嘅時候，我哋做跨境調解活動或者做國際嘅活動嘅時候，咁我哋嗰個培訓需唔需要加強呢？呢個呢係亦都大家要考慮啦。我哋香港好幸運成為呢個大灣區嘅一部分。頭先律政司副司長都講咗好多關於大灣區，我哋會同大灣區一齊協作。咁我哋喺嗰個培訓同埋認證方面，點樣去同大灣區對接呢？咁嘅時候，抑或我哋喺規管嘅時候係本地嘅調解員，我哋一種規管，然後跨境國際嘅時候係另外一種規管呢？但係亦都有個問題就話，咁我哋是否歡迎大灣區甚至國際嘅調解員嚟到香港提供調解服務？種種問題呢，都需要大家去思考嘅。CIPA 呢個框架裏邊，我哋依家係有通過呢個香港國際仲裁中心啦，同埋另外一個機構嘅時候有個名冊嘅。咁個名冊裏邊嘅調解員呢，都係要具備一啲呢係國際投資爭端嘅技巧，要讀過嗰個課程嘅。咁所以嚟講就話，我哋向前行嘅時候，當我哋講專業化或者做得更好強化嘅時候，我哋是否係喺現階段嘅調解員裏邊叫佢或者邀請佢多啲學習，還是我哋要架構去規管，就話你要考到某個試，得到某個專業認證，先至可以咧係去到另外一個階梯咧？呢方面嘅時候，我相信唔單單係香港，其實所有調解推動嘅司法管轄區咧，都係面對緊呢個問題嘅。好啦，呢個我會好簡略講啦。香港依家暫時嘅調解認證咧，可以用中文，中文嘅意思係粵語，可以用英文。咁但係我哋回歸都係一段好長嘅時間啦。雖然我普通話覺得爛啫，但係我都係支持我哋咧要多學習嘅。換句説話嚟講，調評會或者香港嘅同業，亦都要總體去諗下，就係話我哋去考核嘅時候，如果有無論係香港或者香港以外嘅人，希望用普通話去考核我哋香港調評會嘅試嘅時候咧，咁樣咧，我哋應唔應該有個配套咧？咁
If we can include 普通話 into our classification system, so our training experience and certification experience can also be shared in the region. And last but not least, previous speakers also talk about there are some international training centers and organizations. And I think we have watched the videos already. We will use the last minute to talk about one point. Training certification is a big business. In the world of mediation, a lot of mediators thought that a lot of mediators would take training as a tool of profiting. We can learn a lot from training. However, how can we ensure that the mediators that have gone through the trainings that can contribute to the mediation sector and cooperate with other jurisdictions and deliver a good performance? It is something we have to be aware of. And because business is in our genes. If we want to help Hong Kong to become an international mediation center, we must help our next generation to select the capable persons to be in charge of the training of the sector. We should not only treat this as a business. And now it is the end of my sharing. Thank you very much. Thank you.
感觉啊，引起的可以值得分享的一点呢，是香港的那种它的这个调解制度是最早是从司法制度改革开始的。那么它从一开始就是立位于司法制度的改革，所以它有一种比较高的起点，这是我认为是非常值得我们推动的。第二个，律政司的48项建议提出了调评会的这个制度，我感觉这个从政府的角度能够对我们的调解员的资格的认定和培训给予关注和制定标准，我认为这也是我们值得关注的。第三个，香港的调解员是分2种，它可以是开放式的，所以刚才您提出的，在那个大湾区里面，我们能不能跨境来进行调解？我认为是已经符合条件了，因为你们是开放式的。当事人假如选定，更好的体现当事人意思自治原则。当时我认为
in Guangdong, and this mediator, actually in Hong Kong's system, this can be conducted. I believe this we can really share the experience over there. Thank you very much for your sharing. Next, let's invite the previous chairman, Mr. Xiao. Former chairperson of Hong Kong Mediation Council Limited. Let's invite him. I'd like to discuss the professionalism on the international commercial mediation. And dear guests, leaders of different organizations, and dear guest speakers. Previously, from Professor Yan, he also already gave us a trailer that the last speaker will not speak perfect Mandarin. Hope that you can balance your expectation. I'm very delighted to be able to share my personal opinion on international commercial mediation. So I'm going to be humbly invite your own opinions on my sharings. The first part, I will cover several parts. The first will be the requirements of the mediators. The second will be the systems and the trainings, relevant trainings. I will divide my speech into 4 parts. Some of the previous speakers has already mentioned their standards on their own mediators and also the procedures of the training and the skills how to train, and then including as well as how the bureaus will try to involve in this different cases and how to mediate the contents of the agreements. Also, specific expertise, the knowledge and the skill sets are required, including the national laws and regulations should be understood, because different countries have different regulations. So the mediators is better for them to acknowledge the local regulations and laws. Another aspect is the how to operate for listed companies, how to deal with the cross-border mediations. So we have different rules and regulations in all these areas. We have one issue in similar areas. The new mediators may not be required to fulfill the high requirements. So, co-mediation if it requires lawyers from two countries, in this case, or specific experts in specific area or field is needed to participate in the mediation. And experienced mediator is required. Sometimes, in other cases, some not so experienced junior mediator will ask to cooperate with experienced mediator to work together in certain cases. Our guest speakers have already shared their wonderful insights in these areas, so I will not go to details in these things. I'd like to mention management consultant regarding their fees. I believe that their fees charged are pretty high. I believe that we are the consultant employed by the organization. So the fee should be relatively the same or the same level with the mediator. However, in some different regions, some of the mediators will work for free for different cases.
I think it's contradictory. It's dragging the whole process behind. So I hope going forward, no matter it's mainland China or Hong Kong, they could consider this factor into legislation, because most professionals, be it barrister, engineer, doctor, they also charge. So for mediator, it doesn't make sense if we provide free service. And if the client feels that you are my mediator, but my dispute actually contains several billion, they hope there will be an expert to help with the mediation. But if we charge them for free, they will feel, just imagine there's a doctor, a brain doctor, will he charge free? No, that's not possible. In Hong Kong, our public hospital charge is reasonable. So for doctors and nurses, they earn a decent amount of money. So for public hospitals, its charges, let's see, if you live one night there, it's around 180 Hong Kong dollars. I have a friend, he is a lawyer. There's 4 bridges that needs to be installed into her heart. He lived there for a long time, and every night they only charge 180, including the operation fee. But if he goes to a private hospital, the charge may be over $1 million. So I think for mediators, if we want to establish a professional image, we must charge a high price. And now let's come to the next one. We have already had mediation in 1970s, and now it's almost 50 years. However, we still don't have a chamber or a guild or association. In Hong Kong, we have Hong Kong Lawyers, Bariters, Architects, Engineers, Accountants Association. They all have their associations. However, for mediators, we have 50 years of history. Still, we don't have an association or a guild. I hope that our colleagues or peers could set this high as your agenda. Because once we have a guild or an association, mediators could stand together, strive for better reputation and better image. Thank you so much for listening. Thank you, Mr. Siu. What you mentioned, thank you so much for mentioning that. I'm very interested. Just now, we had somebody saying about charge and fee. Two people, one is client, business entity. They feel if you can solve the dispute for me, I can pay the mediator or the lawyer. So I feel the fee is very critical to the commercial mediation process development. So your 50 years of history and experience is much more advanced than us. We are only 10 years or so. Second one is about guild or association. In Shanghai, we also brought similar topics. The purpose of establishing such a guild is to provide training, management, or punishment to the mediators. It's a very structured management rule. In Shanghai, we proposed if we could establish a nationwide association. People say that's not possible. So we could only serve as a mechanism, do it in the civil area. I hope going forward we could solve the pain point. Thank you so much, dear guests, for your sharing. And their sharing is really inspiring. I'd like to see if you have any questions from the floor. 2 questions, please. If no question, on behalf of the audience, I have 2 questions. First question, I'd like to ask my Hong Kong peer, Mr. Lun. In Hong Kong, in terms of mediation, accreditation, association, how do they operate? Is it self-initiated or is it actually guided by DOJ? Thank you. So for this association, its establishment was in early 21st century. Firstly, at that time, Hong Kong had various mediation training associations or organizations. After users graduated, they would like to have a common interest. So Hong Kong government at that time thought mediators' qualification, we must control that. At that time, we had various training organizations. So the way to control it in Hong Kong was not to tell them, like, don't do this, don't do that. Instead, through an industrial land, that is something established by the association, we were encouraged by government policy. At the very beginning, it's more like a limited company. We had several directors. They are also the legal people. For example, we have Barrister Association, etc., joining us. Initially, there were only 4, and now they have 10. Under their concerted efforts, we built up a system in terms of mediators training, assessment. We have very strict rules. The concept was training must be accredited by the association. However, for assessment, so we separated assessment and accreditation. Through this mechanism, we hope in Hong Kong, mediators can reach a certain level of proficiency. Second question, also to my Hong Kong peers. You mentioned business entity and agents training. So what is the timeline? Was it like at the time of the mediation, or you do this on a regular basis, or more like a cultural training? Thank you. I think in Hong Kong, a lot of times we do mediation. It's more like clients come to us for mediation, but when it comes to training, as Professor Leung mentioned, each organization, their trainers have accreditation, and with that accreditation, they can start the course as long as they have students. And after the students' graduation, they need to go for the test at Accreditation Association. And if they pass, then they can become the mediator. And the students actually, they don't have a clear understanding on commerce mediation, because people from all walks of life, they can be mediators. So for training, we tell more about sentiments, techniques, not too much about industry, commerce, or infringement. We didn't touch too much in terms of these areas. Hope I answered the question. Thank you, Mr. Su. Your Mandarin is good, very good. Hope going forward we can communicate in Mandarin. That will be smoother. Thank you. Thank you for the compliment. So that's pretty much of our session here. Now let's go for a closing. MC, please, I'll hand over the floor to you. Thank you, Yuki. Thank you, speakers. Big round of applause. Please stay on the stage. One step forward for a group photo. So stand in the center of the stage, please. Front and center. Thank you. Please be seated. Thank you so much for your insights. So the 6th Hong Kong and Shanghai Mediation Forum, before we end, let's invite organizers, Mr. Shi, to give us a closing remark. Welcome, Mr. Shi. Distinguished leaders, experts, mediators, lawyers, online and offline guests, ladies and gentlemen, good afternoon. I'm very happy to be here at this event organized by DOJ, Shanghai SCMC, Shanghai Law Society. Very happy to be here at the 6th Hong Kong and Shanghai Commerce Mediation Forum. Happy to see all the friends working together to promote Hong Kong-Shanghai commerce mediation. With our concerted effort, we finished all the things on the agenda. We are coming to the end. Thank you so much for your support. November the 5th, President Xi extended his letter to the 5th China Import Fair. He mentioned China will unswervingly become the important connector for world development. We will unshakingly stick to high-quality development and promote economic globalization towards a more open, inclusive, mutually beneficial, balanced direction. One day before, that is yesterday, Hong Kong and Shanghai 20th anniversary signatory meeting was held in Shanghai. Our Chen General Secretary and Mayor of Shanghai, together with Zhang Li, Chief Executive of Hong Kong, attended the ceremony for the deepened relationship between Hong Kong and Shanghai to leverage each other's advantages, to promote Hong Kong, Shanghai's collaboration to a higher level, to work together hand in hand to contribute to the country's development and brighter future. We made several arrangements in these regards, and we mentioned we need to tap into the Import Expo to extend economic cooperation. Hong Kong and Shanghai, we had very deep collaboration history in legal services, and there's more to come in the future. Hong Kong and Shanghai commerce mediation has become a major item for our collaboration in these two places. This year, we are seeing the 6th forum. It's also falling under the Hong Kong Legal Week DOJ flagship seminar. Is conducive and helpful for companies in these two areas to select mediation and honestly and unswervingly implement the settlement agreement. It's very helpful and pave a way for the future collaboration. Just now, we supported and cared for the commerce mediators, all the experts and friends who are interested in this. They all shared their understanding and insights around this topic today. I love their high-quality remarks and 2 insightful discussion panels. They are very inspirational. For me, I learned a lot and deeply inspired. I believe you have the same feeling. Today, the forum quality
is pretty high, so we have the right reason to believe that the future of mediation services will welcome a brighter future. China is the organizer, initiator of the Belt and Road country, and also the first batch of signing countries of the international certain laws in this particular area. So we are encouraged to promote further in this particular area to master this historical moment, to promote our cooperation together domestically and internationally. I believe today's forum helps a lot in promote and the development, in promotion and the development of the further development of the commercial mediation services. We actually in Shanghai set up different legal organizations regarding the mediation regulations and rules, relevant documents and rules in order to promote an efficient practices in solving commercial mediations. Every year, we would like to support the trade and the trade center in Shanghai to sponsor different activities like the speaking contests in Shanghai. In the future, we would like to cooperate further with all of you who are on this platform today to promote further and make sure that we can use full benefits of this forum. Together, we would like to build the highland of the center to resolve the international disputes, commercial disputes, so that we can benefit the world with our cooperation. On behalf of my organization, I'd like to express my heartfelt thankfulness to all of you for the organizers that you have put the great efforts to make sure this is a forum. This forum is a success. I hope that everyone could have a bright future and a lovely family. So I declare that we have this forum is towards an end now. Thank you. Thank you very much for your sharing. Dear guests, ladies and gentlemen, thank you very much for participating in the 6th Shanghai-Hong Kong Commercial Mediation Forum. I'd like to sincerely thank all the speakers, guests, and hosts for their insights and wonderful sharing. And I also thank all the guests who participated in the forum online and offline for making this forum a successful conclusion. Please, everyone, return your headphones to the help desk outside the conference before leaving and take all belongings with you out of the conference hall. You can scan the QR code at the menu to fill in the submission form to providing your unique opinions. You can also fill out the submission forms online. Thank you all. And also, those who need the on-site guests who need continuing professional education development, CPT credits are required to register their attendance record again at the register desk outside the conference hall before the start of the afternoon program. Thank you. This afternoon will start at 2:30 for the afternoon session. If you would like to participate in the afternoon sessions, please return to the hall before 2:15. So you can register your attendance outside our hall. Thank you very much.